you want to sleep at night, you want to keep the money. That the lawsuit is not even reasonable for either party, because it might be more money spent on lawyers than winning.
Hej allihopa, or hi everyone as we say in English. We're here today to talk about business law as usual, and we have Kat, our business lawyer, here with us. We're so happy for that. Today we're going to talk about something very, very exciting, which is the 11 ways to avoid that your company gets into a lawsuit.
When you're selling it.
Yeah.
Because, I mean, if you finally get there and get to sell your company, you want to sleep at night. You want to keep the money.
Right, definitely. Because it's a big thing. I mean, selling your company, I would be so nervous for that.
I mean, imagine ending up, instead of celebrating and going to the Bahamas, ending up in the court in a lawsuit.
No.
I think it does happen. So we're going to try to help you here with the key takeaways, what to think of to avoid that happening.
That's so good. That's why we're here.
Yeah.
So we're going to talk about 11 different ways. So we start with number 1.
Yeah.
What is that?
Bring in the pros and bring them in early.
Why? Tell me more.
Because it's a big thing to sell your company. I mean, imagine you're selling it for 10 or 100 million. Spend 25,000 on the lawyer. It's worth it. In particular, if the buyer has their own lawyers and they are the one drafting the agreement, I promise you it will be very harsh on you. There will be terms and conditions that make it easier for the buyer to come after you if there are any issues. So make sure you have some kind of professional help and have it early on rather than spending much, much more in the lawsuit later on.
Number 2.
Do not leave it all up to the pros. Because I see that happening also, that the buyer and the seller, they're like happy and just make the deal. And they put us lawyers in a room together and we get down to nitty-gritty. Make sure you're present so you know what's happening. You know what you're signing because it's your responsibility. And that you two are talking, have a good communication. That will also help.
Good. Number 3.
We've been on this on the due diligence, but transparency. That's the best protection for you as a seller. That means that everything you show the buyer basically will be seen as price in. So any issues coming up, if you disclose that during the due diligence, it will be impossible or extremely hard for the buyer to come after you unless you sign a specific indemnification for it. But then you will know that you have done that.
Okay, so be transparent.
Be transparent.
Number 4.
That is, avoid unclear language in the SPA, the share purchase agreement. Because sometimes, I mean, imagine if you write working capital, but you have not defined it. That's a rather complex term, and my definition and your definition might be different. And that can, in itself, mean that we end up in a lawsuit because we have different perceptions and we don't know who's right or who's wrong.
Okay. Number 5.
Avoid over-engineering. You might think that if I outline this and that, and if this happens, and then the earnout, and then that will be 5 years and a longer agreement will not be a better agreement. Because what happens is that we risk that there's contradictions and that there will be gaps instead. There will be workarounds. So be mindful that longer will mostly mean more expensive lawyers in the beginning and perhaps not better protection in the end if it's over-engineered.
Okay. Number 6.
That is the price mechanism and the earnout. Make sure it's very, very clear. Because completion accounts, you can start fighting over how you calculated it, if you get to audit the accounts or not. Earnout, even worse. Something happens, your cost allocation, what headline you're aiming for. So make sure it's very clear cut, the price mechanism and the earnout that you are using.
Yes, and we also have an episode about price mechanism.
Yeah.
Which is very good.
Good to watch.
Yes, and it's about the price you get for the company.
Yeah, and how you adjust it, because the price you decide is based on historical facts, and then you have to adjust it at closing.
Right. Number 7.
Number 7, the warranties. Make sure they are qualified. That is, that they are not absolute. You do not promise that there are no lawsuits against the company. You promise that as far as you know, and same as has been disclosed, there are no lawsuits against the company. And that will be a push and pull between you and the buyer. So it won't be an easy one, depending on how savvy the buyer is. But try to make them qualified. That's a much better protection for you.
Good. Number 8.
Limitation of liability.
Yeah.
Super important. So even if there is a breach against the contract by you as a seller, you can make sure that you will never have to pay more than X amount. So imagine that I send my company to you for 250 million. Then we can say that my cap is for 200 million. So I know that no matter what, I will not have to pay you more than that.
Is it common that you forget about the limitation on liability? Or
if you're the weaker party, the less experience, you might be pushed to a reasonable one. You might even, if they really want to buy it, you might push it for 100 million or 50% of the purchase price. And you will not be able to have that limitation on the fundamental warranties, which is basically that you own the shares and things like that, and that the company exists. And you will not be able to do it if you're being fraudulent, but that's okay, right? And then you can also limit it in time, how long the warranties will last, 2 years, 1 year, that's a really good protection for you. And then the type of damages that you will have to pay, that you can also limit. You can say no indirect damages, no third-party claims, and so forth. And that's a really good protection for you.
Yeah. Limitation on liability.
Yeah.
Number 9.
Do not forget the soft values. So make sure you have good communication. Like any business, any deal, if you are talking to each other and you like each other, the way to the court to find that lawsuit is much further away. Good communication in the beginning is worth it in the end. We see it time and time again that the lawsuit is not even reasonable for either party, because it might be more money spent on lawyers than winning, but you're not talking. So you want to nail each other.
Okay. So soft value is good communication.
Yeah.
Number 10.
And that is have an escalation process, a dispute mechanism where you start with mediating. So you not directly go for that lawsuit. You have to meet or a third-party mediator, something softer. So you try to resolve it earlier on.
Number 11.
And that is, we're talking about the buyer and seller, right?
Mm-hmm.
But what about minority shareholders, if you have one?
Yes.
Or some. Make sure they are on board. Avoid using a drag-along, forcing them to sell or pushing them over it in some kind of hostile negotiation. If you can, make sure that everybody's as excited about the deal as you are.
That sounds really good.
That's it.
That was the 11 ways.
Yeah.
11 ways to avoid that your company's sale goes into a lawsuit.
Yeah. And we really do hope it helps, because we see it time and time again. And a lawsuit, take it from me as a lawyer, not worth it.
No.
It's stressful. It's financially, it's just chaos.
Yes, and a company share should be something that you celebrate, because it's a big step.
And you want to sleep at night.
Yeah, you want to do that. So that was the 11 ways to avoid your company sale goes into a lawsuit. And thank you so much for explaining this for us. If you have any more questions, please drop them down below. We're here for you to answer these questions, because business law, it can be very complex sometimes and you feel lost in the business world.
We're here for you, and please share your experiences and we'll pick them up and we'll help each other out.
Exactly. Thank you.